members, I would like to start by accepting the committee's amendments proposed in the analysis, and I want to thank the committee staff for their work. As amended, AB 1916 requires private post-secondary schools to file a surety bond in order to provide additional consumer protection for students in the event of a school closure. Recent closures of for-profit schools have shown that many academic institutions are exempt from the Bureau for Private Post-Secondary Education's oversight and the financial protection offered by STRIF. Also, as shown in the analysis, after recent school closures, very few students have recovered their economic losses. Requiring these institutions to maintain a surety bond will protect students in three important ways. Students at the 617 schools exempt from the Bureau's oversight who currently have no form of protection can recover their economic losses through the bond if their school closes. So again, I want to repeat, there are 618 schools where students are not protected at all. For students at STRIF-covered schools, the bond would provide reimbursement to the Bureau for enforcement and outreach efforts to connect students with the benefits they deserve. None of these things are currently covered by STRIF, and it is not double coverage of these students. And again, the reimbursement rate for STRIF, the students that were at bankrupt schools, very few of them have actually been able to get their money back from STRIF. And lastly, under this bill, surety bonds would cover punitive damages attributed to the institution, creating a strong disincentive for schools to engage in activities that may harm or mislead students. According to the National Consumer Law Center, California is one of only 10 states that do not require a surety bond to be maintained by for-profit schools. So 40 states are already requiring this. Also, 13 of these states currently require schools to obtain a bond that protects students against damages incurred as a result of improper actions by the institution. This is a proven policy that will provide California students with these protections. Lastly, I want to address some of the arguments made against damages being covered by surety bonds. Because the amount of these bonds would be capped by the formula established in the bill, the liability of the surety would be fixed and therefore is limited. This does not make this an insurance policy, and the surety industry has made it clear to us that they would offer these bonds, which are similar to those required of state contractors and just like those required of private colleges in many other states. The simple reason for this is that with this protection in place, institutions cannot close as a means of avoiding damages awarded by court. AB 1916 will ensure that all California students have these very reasonable protections and that the students trying to advance their lives through education do not fall victim to illegal actions. Thank you.
Hi, my name is Jill Rice. I'm with the California Federation of Teachers, and we're here in support. Assembly Bill 1916 takes a forward-thinking and a preventative approach to the problems that were caused by the abrupt closure of the Corinthian colleges in 2015. This bill, as Assemblywoman Irwin noted, will bring California in line with the vast majority of other states that already protect their residents from such harms that are closed by these closures. At the time of the closure, there were more than 13,000 students enrolled in the Corinthian colleges that were not eligible for other forms of relief. By requiring these specified for-profit and other post-secondary institutions to secure a surety bond, this will help mitigate the damages that inevitably result from such a sudden closure of a school. The California Federation of Teachers believes strongly that California students should never be punished for working to better themselves, their families, and their futures through higher education. While the state can do very little to prevent the schools from closing, the state can take this very important step in protecting California students from the untimely closure of institutions of higher education. And we urge your support of this important bill.
Good morning. My name is Olivia Philbrandt, and I'm here on behalf of Attorney General Kamala Harris, and we are in support of 1916. Thank you.
Thank you. Additional testimony and support? Hearing and seeing none, let me ask for testimony in opposition. Please.
Mr. Chair and members, Scott Governor on behalf of the University of Phoenix. We support requiring a bond of the 617 schools that aren't covered under the law. Unfortunately, the way the bill is drafted, you have to buy an insurance policy for 100% of your students. That's how the bill reads today. If they'd like to fix that, we think that's a great change. In terms of the punitive damages, my client operates in over 35 states. Not one state requires punitive damage bonding. As a matter of California law, Insurance Code 533, California Supreme Court case, and common law, you cannot bond punitive damages. That would be akin to allowing someone to buy fraud insurance because they think they may commit fraud at some point. You can't do it. It's against public policy. Nevada, which is often pointed to, its actual damages, and the bond amount for my client is $10,000. Getting to the actual cost of the bond under the bill, depending upon how one interprets the term program, at the low end, the bond amount for my client, which on the federal financial stability scale is at the top, they are considered a financially stable school, would be $8 million. At the high end, it's $2 billion. Can't do it. We're saying the bond has to have some form of a cap, and it needs to take into account the financial stability of an institution as determined by the federal government. With those changes, we think it's a viable bill, but until that time, we simply oppose the measure.
Mr. Chair, Matt Back, representing CAPS, California Association of Private Post-Secondary Schools. We represent about 200 schools that are regulated by the Bureau. They are all covered by STRIF. We, like Mr. Governor, for those 618 schools, which, by the way, the legislature has approved their exemptions. We're talking about very limited programs here. These are $2,500 or less. There's flight schools, there's religious schools, there's nonprofits. These are not the Healds anymore or the University of Phoenix. These schools have gone under the Bureau for Title IV protection under federal law called state authorization. So all of these schools are now under the Bureau, and their students are protected by STRIF. It is true Corinthian had healed because, 6 months, if Corinthian would have closed 6 months later, they would have been covered. It was just an anomaly, and it's unfortunate. And we do support those students getting some relief. There was a bill last year that we tried to help some of them. But like Ms. Eggman's bill, she has a bill that would require STRIF for those schools that are not currently regulated. We support the concept of allowing students who are not currently protected to get protection. It is extremely duplicative to require our schools now to get a bond, even though their students are protected, one, by the federal government. If we were to go out of business, those students can get their loans forgiven by the feds. That is absolutely the best option. Second option is you go to the STRIF. It's a legislative cap of $25 million. It's actually $3 million over the cap right now. So there's $28 million sitting available for students. This bill would now require us to get a bond on top of that. Again, all institutions, not just those exempt. And like Mr. Governor said, depending on the size of your school and the way it's written, it could be $1 billion bond. And with all due respect to the companies that maybe they've spoken to, we've spoken to many, it's not bondable. So we're not going to be able to get the bond. We then get kicked out of the Bureau, and we're not, the students wouldn't have the protections under the Bureau. So with all due respect to the amendments that the committee has offered and to the author, we simply cannot support the bill as drafted. We would support a bill that limited it to those schools that are not covered by the Bureau. Thank you.
Thank you. Additional testimony in opposition.
Mr. Chair and members, Fred Jones on the Professional Beauty Federation of California on behalf. We did send a letter of concern to the author rather than opposition a few weeks ago in the hopes of being able to work with the author's office. But we remain opposed to the current version of the bill for all the reasons Mr. Back so eloquently summarized. Some of my small beauty schools have actually reached out to their insurance brokers and asked them about bonds, and they were told they would have to open up all their financial records, and that even after a very thorough examination, they weren't sure they would be able to offer them a bond. So this could be expensive, difficult, possibly even impossible for some of my small second, third generation family beauty schools. So we believe there are existing protections for students, and if students are already paying for STRIF and schools are already regulated by BPPE and the federal government is willing to forgive loans for school closures, we believe that's sufficient. Thank you.
Thank you. Additional testimony in opposition.
Mr. Chairman, George Miller, on behalf of Education Management Corp., parent of Argosy and the Art Institutes. echoing the comments of Mr. Back, and we also, we, like the author and Mrs. Eggman, feel that covering the students who do not have coverage right now is an important step that needs to be taken. We want students that enroll in our institutions to have that level of security, knowing that if something, unbeknownst to them happens and they are not allowed to further their education, that they will be covered. That being said, at our schools, 90% of the students are covered under this STRIF. There are those 10%, roughly 10%, that would not have coverage today that we feel should somehow be taken care of. But the whole idea of double covering the 90 to get the 10 is an extremely cost-prohibitive issue, as well as as was mentioned, the idea of insuring for punitive damages, which is contrary to common law and state law. Thank you.
Thank you. Additional testimony in opposition.
Jennifer Tannehill with Aaron Reed and Associates on behalf of the American Career Colleges West Coast University. Just want to voice our opposition to the bill for the reasons stated. Specifically, the punitive damages in the bill are a huge problem for our folks, as well as the bond requirement with no cap. Thank you.
Thank you. Additional testimony in opposition.
Kathy Van Austin, MBM Strategy Group, representing Bridgepoint Education. Bridgepoint's the parent, of Ashford University, as well as University of the Rockies. Ashford students are covered by STRIF. University of the Rockies is not. It's a much smaller school. That we do have students in California. We take no issue with bonding to make sure that we can make sure those students are protected. We'd love to work with the author to try to reach some accommodation on this bill. We are not opposed to a bond whatsoever, so just hope to work with the author in the future on this, and at this point just have to oppose the bill.
Thank you. Additional testimony in opposition. Hearing and seeing none, let me turn it to members on the dais, but let me first begin by addressing some of the concerns raised by the opposition. I know, Ms. Irwin, you and I have discussed some of them, and I know our staffs have been talking as well on the issue of the term program, if that could be construed as 6 weeks. I know you touched upon it a little bit in your opening statement, but maybe further defining what that means, whether it's a multi-year program or a 6-week course.
Right, and we need to make that very clear. What we see as the program is if it's every time the students pay. So if it's a 6-week course and then they have the program is basically 6 weeks. I don't know of any school that charges tuition a year ahead of time, and that's basically because you want to make sure there's enough money in there to cover the student that the students get their entire education. Now, for some of the very large schools, in particular the largest school, we would certainly look at a cap to make sure that they are not financially burdened. The main thing we want to do is protect the students, and we do not want these small companies to go out of business. But having a bond is not going to make these companies to make these companies go out of business. Again, 40 other states require a bond. And I just wanted, the other thing that I would like to address is the insurance punitive damage portion of it. The insurance code section that's been referred to by the opposition prohibits an insurance policy from covering willful acts of the insured or any penalties determined from criminal action. And the purpose of this law is to make sure that you are being protected against unlimited criminal liability. But this bill does not require institutions to have an insurance policy. The surety bond doesn't fall under that definition. And even under the spirit of the law, this wouldn't apply because the surety bond is set to a fixed amount and therefore limited to the amount that is in the surety bond. And so this bond would provide limited amount of collateral if damages are determined by the court. So I did want to make sure that we address that.
Got it. And if I'm hearing you correctly, so you are looking at a cap to address the opposition, and then also with your last statement, it would be permissive in terms of covering the punitive damages. The other thing I know that we talked...
Well, it would be capped by the amount in the bond. So basically what we have right now is many of these schools are covered by STRIF. but the recovery rate is extremely low. So you can get, we've seen numbers from 2% to 20%, and that's because STRIF is not allowed to spend money on outreach. So the bond would have a number of purposes. One is to make sure that students get the money they're entitled to from STRIF by making sure that there is money for outreach for the board. The second part is if the court determines that there's punitive damages, that can be taken out of the bond also, and that's a limited amount. There was some discussion about the federal government being a backstop. You know, there's no guarantee that the government's going to decide to make these students whole. This is a protection for the students, and it is to make sure that we do a much better job of distributing these STRIF funds to the students. You've seen a number of schools go bankrupt, and yet STRIF is overfunded by it's at $28 million. That money is not getting to the students, so we need to do a much better job of outreach, and that's what part of what the bond would do. So the definition would be by the definition of program and how much money they currently have. We would put if for the large companies, put a cap in there also, and then look at if the amount needs to be lowered because they have a low risk factor, then the amount can be lowered for that also.
And I think on that point, we were talking about the Federal Index of Financial Stability, which is, I think, federally is defined as a financial responsibility composite score.
Right.
Correct, and those are all future possible amendments we're looking at in this bill.
Yes.
Yeah. Okay, thank you. Let me ask for additional questions for members on the dais. Mr. Dodd, please.
So I guess the first question is why are some exempt from STRIF?
I think its legislators have gotten certain schools exempt from the board, and then so they ended up not being covered by STRIF. So I think there's over 600 of those institutions that are not covered.
Mr. Dodd, if I may.
Yes.
The law has evolved. So when the act was instituted in 2009, regionally accredited, so more of a sophisticated regional accreditation, those schools were exempt. Federal law changed and required what's called state authorization. So your home state has to authorize you. So those exempt schools, like Mr. Governor's School, have now gone under the Bureau. So Heald, which was a Corinthian brand, would have gone under the Bureau. They were just months away from doing that. So all of the large institutions are now under the Bureau. There are smaller schools, less than $2,500 programs, some flight schools, religious nonprofits are still exempt, and that's all still in statute. But I think the schools that Ms. Irwin is trying to address, they are all now covered by the Bureau.
With one exception, that is also out-of-state institutions. So there is a national reciprocity agreement which California does not participate in, which is intended to speak to these online students in other states. We think the state, California, should participate in that, but if they elect not to, then we support bonding these online institutions. Because they have no physical presence, they can't be covered under the Bureau.
Okay, and then the other issue, Mr. Chair, that very few people have taken advantage of, the STRIF program. I guess what I'm wondering isn't there, other ways we can attack this without having such an expensive solution to the problem by requiring prior to, going out of business that these companies provide a notice about this fund? It just seemed, I thought this was a no-brainer when I came in here, and I've got to tell you, Ms. Irwin, I am very, very concerned about, defining what the bond cap is in terms of minimizing the expense, and then also, I just wonder, why we need to go into the area of punitive damages. Those are just two of my real big concerns on this bill.
Well,
I like the intent. I like what.
Right, and there are no resources to do additional outreach to the students. That's obviously why the students haven't received the money from STRIF, or that they're being reimbursed at such a low rate. And so the bond again provides those resources to the Bureau to make sure they do outreach. Specifically, they are prevented from using STRIF money for outreach.
Right. I guess my concern, this day and age of social media and everything, you've got all these people at the school, how these students can't figure out that there is an answer to their problem that they can get compensated for. This is kind of confusing to me as well.
Punitive is, what I mean. Again, there are many schools throughout the country that have these, I guess you would call them punitive damages, but you want to discourage bad behavior. And it is not unlimited punitive damages. It's just the amount of the bond, and the bond amount is, again, if you have a class, if most of your classes are 6 weeks and you have 6 weeks worth of tuition, that's the bond amount. And if you have a low risk factor, then the bond amount can go down. You can appeal to the Bureau.
Mr. Chairman, just following up on that, that's not what the testimony against this bill has suggested. It suggested, for some of these, really large numbers without, consideration of how good the institution is and how the institution is rated.
So, Mr. Dodd, if I may, let me just interject
please,
here.
Mr.
This
Chair.
is
I'll be done.
conversations that we've had with the author as well. So when I was asking her earlier about a cap, she is open to looking at that as an amendment, and then also tying that to the financial responsibility composite score, which would also reduce the bond amount as well. So those are things that the author has agreed to continue to work on as amendments moving forward. But because of the timing between this committee and the next committee and our legislative calendar, we weren't able to include those in this analysis and amendments here. She did accept the amendments that were stated in the analysis thus far. Ms. Irwin, would you like to add to that?
Well, I think the situation they're talking about is that is an extreme situation. That is not what the vast majority of schools are going to have to deal with. They're talking about their biggest institution. So obviously, the amount is going to be the largest. When we're talking about capping, it would be for these situations where they have thousands of students all throughout the country. Yes, then bonding could be could certainly be an issue for them. But for the vast majority of schools, we've talked to the bonding agents, and it's not going to be an incredible amount of money. And we have to remember this is the two goals are to make sure that these schools can continue to stay viable, because many of them offer services that our public schools do not offer. And I always use the example, many of our veterans like the flexibility of these for-profits. But the most important thing to do is to protect our students. And the current situation is not doing that. And counting on the federal government to bail out these students, that's not a good situation either. That's not responsible. So this is making sure that these institutions are behaving in a responsible way, and that there is money to give the students back what they have put in for their education if the school goes bankrupt.
Thank you. Let me ask for additional questions. I think Ms. Eggman, please.
Your goal is laudable, and I think we're all concerned about how do we protect students. I guess I have some concern just because there's no conversation we have in California about the need for more students, more people to be educated to be able to take jobs. And so I guess I just worry a little bit that you're using a giant hammer to be able to get some of these outliers that are, and I certainly just had a beauty shop close in my school, close in my district, and students were left without anything. We never, ever want that to happen. But it just seems to me we already have the STRIF program. You've heard allusions to that. I have a bill later today to put more of the schools under that. Why don't we just work on fixing what we already have versus creating a whole other system to be able to work on this? And I'm also concerned about the nonprofits.
I'm concerned about the
nonprofit schools as well. I mean, we've got the for-profits in there, and again, I think we all need to continue to address, as a classroom university professor, to continue to address the issues of online out-of-state schools. I'm with you on that, but it just feels like a very big hammer to swoop everybody under the umbrella. So
again, I will say 40 states already do this, and a very large number of those programs have the tuition. I think I had read it before. 13 of the schools require something like STRIF and bonding also. So this is not a this is not a big hammer. This STRIF is not working because the money cannot be used for outreach. And so to have a bond there, and for most schools, it'll be a relatively low amount to make sure that those students are taken care of, is, I think, in my mind, very responsible.
So how does the bond, so say school closes, then your vision is the bond will just kick into outreach? I mean,
Then so STRIF doesn't have the resources to do the outreach, so the bond would reimburse the board to do that outreach to make sure that students get their money.
Thank you. Ms. Baker.
Thank you, Mr. Chairman. And I share some of the concerns that our colleagues have raised. And my greatest concern is a statement that you have made a couple of times, which is we got to get money out there for outreach. And Vice Chair of Higher Education co-sponsored the bill last year that the governor did not support on helping the Heald and Corinthian College students. The problem is not that the money isn't there. We have actually sent money to the Attorney General's office on outreach. And when students come and testify, they say, as soon as I found out about the program, the help was there. I just didn't get the news. We've sent it. We're doing a poor job with the funds we already have getting word to students, and I don't see how this helps. And my concern also is that by having a bond that could be very high, we are tying the hands of these institutions to remain solvent to begin with. And they do provide a pathway for those who are looking for different pathways that work for them, as you've recognized. So I appreciate your help on this, but the reality is the outreach funds have already been there. We are not using them well, and I would love to work with you on how we can use them better before we go down this particular path. But I strongly encourage that to be the right approach so that we can keep these pathways open and more solvent, but actually get the word to students, which we're failing to do now as a state. And that's what I would encourage.
Thank you. Mr. Gatto.
So forgive me, I was out for part of the presentation on the insurability of punitive damages, but does this bill purport to overturn the sections of the California Insurance Code? And I'm not sure if this is double referred to insurance, on which I sit as well, but does this bill purport to overturn the insurability of punitive damages?
No, this is for punitive damages because the amount this is not considered insurance. This is the amount is limited by the amount of the bond for punitive damages. So the section that they refer to is not relative.
Could I direct that to? I'll direct that question to somebody on the dais.
It's our understanding that the bond would be underwritten by an insurer who would have to underwrite, and part of underwriting is calculating your risk, and you can't calculate risk on intentional acts. You can underwrite auto insurance, and you can underwrite the fact that people will get distracted and they'll rear end somebody, but you can't underwrite the fact that somebody may see someone in the crosswalk and step on the gas and run them over because they don't like them. You can't underwrite that. And also it's violative of public policy. You do not want that underwriter. You don't want the ability for someone to go shoot guns off in the neighborhood knowing that they're covered for punitive damages. So there's not, the underwriting isn't available, and it's violative of longstanding public policy.
And that's the crux of the issue.
I'm sorry. We have talked to the surety companies, and there are 13 other states that do this. It is not considered insurance because it's limited by the amount of the bond. That specific, what I had mentioned before, that specific court case was to guard against unlimited criminal liability, and so that's not the case in this situation.
So your position is that because the amount of the insurance policy is limited, that it does not have to be subject to Insurance Code 533?
Well, that's what the surety people told us, that it's limited by the amount of the bond. And again, they're writing these bonds in other states.
Correct, but California is a little different in that we've got a very clear code section that prohibits this, in my understanding. I've sat on insurance for a couple of years, and that's my understanding, at least. I realize other states do it. California, though, has this long tradition, case law, statute, that does not allow for the insurance of these types of things. And I'm just curious if we're trying to overturn that section, or even by implication, or...
No, we wouldn't be trying to overturn it. And we do have, we have that specific inquiry into Ledge Council to just confirm our understanding.
Got it. All right. Thank you.
Thank you. Additional questions from members on the dais? Hearing and seeing none, do I have a motion to move the bill? Moved by Mr. Wood. Do I have a second? Second by Ms. Campos. Ms. Irwin, would you like to close?
I think we've had a robust discussion on this, and again, our main intention is to make sure that we protect the students at these schools. Protecting students with a bond is very common practice. It's common practice if you're a contractor that you have a bond. It's so I think that's really we can really get into the weeds on this, but the real simple fact is that this is to protect students.
Okay. Thank you, Ms. Irwin, and thank you for obviously the lengthy back and forth questions and answers, and specifying your intent to protect the students, as you say, but moving forward and addressing some of the concerns raised around the cap, and maybe using the financial indicator. And just, we know it's a work in progress. We're working with you. And as always, with any bill that goes through this committee, we always have the ability to call it back as well, but are very curious and want to be at the table as you continue to move these amendments forward and move this bill forward. With that, it is a due pass as amended to appropriations from the chair. Madam Secretary, call the roll.
Salas?
Aye.
Salas, aye. Bro?
No.
Bro, no. Baker? Baker, no. Bloom? Campos? Campos, aye. Chavez? Daly? Daly, no. Dodd? Dodd, no. Eggman? Gatto? Gatto, no. Gomez? Holden? Jones? Mullen? Mullen, aye. Ting? Wood? Wood, aye.
That bill is 4-5. That measures on call.
All right, thank you.
Yes, please. Okay. Let's move to members. File item number 6. Assembly Bill 2385 by Assembly Member Reginald Jones Sawyer, the third or senior?
Senior.
Senior.